on the Federal Competition and Consumer Protection Commission. I think a very good way to start would be a basic understanding of the legal framework in Nigeria. By way of institutional history, the Federal Competition and Consumer Protection Commission was originally the Consumer Protection Council, and it only had one mandate, which was consumer protection. However, in 2019, with the presidential accent to the bill, the then bill, and now the Federal Competition and Consumer Protection Act, we now have two mandates, not just consumer protection, but also competition. And you will find in the course of this discussion why that became an issue at some point in the conversation. And you've heard Professor Claudia also talk about the intersection between competition and consumer protection and all of that. But besides the FCCPA, we also have the Constitution, and that's the grundnorm. That's the most fundamental law in the land for which the FCCPA draws its legitimacy. The Constitution, I believe, is Section 37, and makes it very clear that Nigerian data subjects have a fundamental right to privacy. Their right to self-determine how their data is collected, is used and democratized. We also have the Nigerian, at the time when this investigation started, we didn't have the Nigerian Data Protection Act, which we now do. But we had the Nigerian Data Protection Regulation, and that was also, again, responsible for the regulation of how data was democratized and the portability of data. So in terms of scope and jurisdiction of the Federal Competition and Consumer Protection Commission, Section 2 is very clear. As long as it is a commercial activity that has effects in the Nigerian market, the jurisdiction of the FCCPC will apply. We also have a Section 17 that allows the Commission administer and enforce any law that borders on consumer protection and competition. And with respect to consumer protection and competition, and subject only to the Constitution, the supremacy of the Federal Competition and Consumer Protection Act is established. So that's the legal framework, and that provides the legal basis for which we're able to look into this Meta case. Sometime in 2021, I believe it was January 2021, the Commission became aware that Meta had updated its privacy policy. And what was shocking to members of the panel was, the investigative panel, was the fact that Meta had originally informed the Nigerian data subjects that if they failed to update their privacy policy by, I believe, sometime in May of that year, 2021, they would no longer be able to use the WhatsApp services. And that became quite suspicious. And so what the Commission did was immediately issue what we call the order and notice to show cause as to why we shouldn't consider this a serious investigation to look into. And Meta's response was, oh, don't worry, this is not a big deal. There's no consumer protection concerns or competition issues that our policy raises. There are no consumer harm. We're only just trying to be transparent. We are not sharing or doing anything different from what we were doing in our 2016 privacy policy. Again, that response for the Commission was considered suspicious, and members of the panel decided to now look in depth at the privacy policy and compare it with other privacy policies all over the world, particularly in Europe, because we found that the regulatory environment is quite similar with that of Europe. And we then developed our theories of harm, which includes definitely a lack of consent, and we've seen it even in the way that Meta operates, even in Europe. the lack of consent. We saw a lack of compliance with the Nigerian data protection regulation. Again, you can't say to someone, it's a take it or leave it situation, a pre-tick box. In essence, if you don't accept this privacy policy, you can no longer use the service. That was so the commission concluded that everyone who accepted the privacy policy at the time was under duress. And so that was an established theory of harm. We did recognize that or accepted the position that Meta took with respect to, oh, nobody lost functionality in the period, even though, yes, we did threaten them, but, you know, no one lost functionality. They all accepted and gave consent. And we said, no, that consent wasn't freely given. It wasn't in compliance with the Nigerian data protection regulation. And so we would say that it was an absolute lack of consent. When we compared that with the Nigerian data protection regulation and the general data protection regulation that applied in Europe, we also found that Nigerian data subjects were discriminated against. For instance, in Nigeria, once you have given that consent, even though it was still not freely given, but once you've given that consent, you cannot withdraw the consent. This is very unlike in Europe, where you are able to withdraw the consent. But more egregious was the fact that the Nigerian data protection regulation sort of mirrored the general data protection regulation. So there was no reason why Nigerian data subjects could not get the same or similar protection when it comes to withdrawal of that consent, particularly because you have mandated them and you've given them a pre-tick box to grant their consent or not use the service. And then if they did change their mind, I'm sorry, the only way to withdraw your consent is to delete the app. You know, and so we found that to be troubling. So another theory of harm was the tying and bundling. What had happened was that Meta was using the privacy policy to tie their WhatsApp market with their Facebook market and all of the other Facebook family. For instance, whatever data WhatsApp is able to collect, whatever cookies they're able to embed in your phone, whatever tracking system that they have, once they've gathered that data, they're able to profile you. And once they profile you, they can share that data with other Facebook companies. And this is not just Instagram or Facebook. It also includes third parties, you know, and for all of this data that is collected, you just get this one consent pre-tick box, and that's it. They're going to share your data. So that was, these were the theory of harm for the commission, and we found it to be one, an unfair business practice and an abuse of dominance. And we're able to do this by delineating the market. Of course, this was another challenging aspect of our work, and Meta had insisted that the market was global in nature. However, we took a more narrow point of view. We looked at the geographic location in the sense that in terms of geography, the effect was felt in the Nigerian market. And so there was no way you can say that it was a global market. We also looked at the privacy policies. We realized that Meta had privacy policies for different regions. And so you can't, on the one hand, say you're a global market, but then you've delineated the market yourself with your privacy policies, as it were. We did a market study also to support a lot of our findings or to corroborate those findings. We also were able to look at the unique products that Meta was offering compared to a Facebook, for instance, where is double or multi-sided. The WhatsApp market was single-sided. It was a one-sided market, zero price, as they call it. But then the kind of data that was being collected was excessive. When we looked at the market participants, we saw that Signal somewhat operated in the market. Telegram operated in that same market. Meta and WhatsApp was in that same market. They were doing similar things. However, Meta would like us to believe that it was a market for the attention of consumers. And so we could bring in the LinkedIn, the YouTube, Netflix, and Zoom. But we looked at the unique features of the market. We saw that it was single-sided. We saw that it was contact-based. We saw that it was more family, group, church type friends related, as opposed to a marketplace like Facebook. And so we were able to say, no, we understood what the market definition should be. We will take it, we'll take a more narrow look at the market. We decided who the market participants was. Again, we relied on the economic analysis in the market study. And then we looked at other substitutability, the high switching costs, because most of the data subjects were using WhatsApp. They didn't want to switch from WhatsApp to any other platform because they didn't see any reason why. Most of their family and friends were there, and the switching cost was high in the sense that it was going to take time to get your family and friends to move to a different platform just because of you. We also looked at the quality issue. We agreed that the more data was collected, which we also analyzed that, we saw that Meta was collecting unnecessary data points than when compared to other market participants. And the likelihood of collecting this amount of data when compared to the security of such data was very slim. I mean, the more data you collect, there's a degradation in the security of that data. And that was how we looked at it. And so we found that beyond the amount of data that Meta was collecting, we looked at their technological links, and we came to a finding that indeed, whether it's with respect to the market structure, the amount of data points being collected when compared to other market participants, WhatsApp's technological link with Facebook and Instagram, and the difficulty that other competitors will face in expanding because of the high network effects and lock-in effects. We were able to come to the conclusion that you are dominant, and your conduct of denying Nigerian data subjects their rights to self-determine how their data was democratized, shared, collected, stored, was an abuse of that dominance. The fact that you were tying your WhatsApp market to your Facebook and potentially Instagram and other third-party markets was anti-competitive. And so, the discrimination against Nigerian data subjects with respect to how Meta chose to comply with the Nigerian Data Protection Regulation as compared to the General Data Protection Act in EU, we were able to come to the conclusion that we had met the standards of proof required for us to bring Meta back to compliance with the Nigerian law. And so we issued a report. We showed them our sources of information. We gave them ample opportunity to respond back to the commission with respect to its position. Again, Meta stuck to their guns as far as they're concerned. Your conversation with your friends and your family is still end-to-end encrypted. Indeed, we're collecting a lot of data, but we're not doing anything different from what we were doing in 2016. And so we were just meeting the transparency requirement. We are not dominant in any relevant market. As far as Meta is concerned, the market is global, it's digital. And so there are no narrow definitions of that market. Again, all of this, the commission disagreed with Meta and has asked Meta to unbundle whatever infrastructure has been integrated to ensure that they do not comply with the regulatory requirements in Nigeria.